Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
All right.
Counsel arguing the first case, please turn on your cameras and unmute.
Okay, I think I see everybody. I hope you can see the panel. Welcome to the November term of court, first argument via the remote platform. I think everybody's gotten used to it by now, and we expect the argument to go relatively smoothly. Try to look for a visual cue and try not to talk over the judges when they're trying to ask a question. But we'll get through. If we need a few extra minutes, that's fine. We only have 3 arguments on our flight this morning. We probably will take a short break after the second argument, and then we'll finish up with the third one after that for those of you that are still in the waiting room. Unless there's any questions, I think we'll get started. Our first case is 19-1390 Brooks versus CDOC. And we're going to have the plaintiff split argument between Ms. Butcher and Ms. Robbins. So I think you have that under control, and you may proceed when you're ready.
May it please the court. My name is Angela Butcher, and along with my co-counsel, Ms. Asia Robbins, I represent Mr. Jason Brooks. For the purposes of our limited argument time today, I'm going to focus my time on the mootness issue, and Ms. Robbins is going to focus her time on the merits of the ADA. We reserve 3 minutes for rebuttal and will otherwise split our time equally. Our supervising attorney, Mr. Matthew Cushing, is on the line and available for questions if needed. As to mootness, the district court erred in finding that Mr. Brooks's ADA claim was moot. Now, this court revived Mr. Brooks's ADA claim in 2018 and remanded the case to the district court for discovery and briefing on the merits. Just 4 months later, as discovery was starting, defendant CDOC sua sponte transferred Mr. Brooks and voluntarily granted him the movement pass he had been requesting. They then argued to the district court that Mr. Brooks's case was moot. But the defendant's behavior did not moot the case because voluntary cessation of offending conduct cannot moot a case out, especially when defendants—
Counsel, did you have the opportunity to brief voluntary cessation?
Yes, Your Honor. That is briefed in our opening brief.
No, I mean before the district court.
Oh, yes, Your Honor. The district court and this is in the record at volume 7, page 561, footnote 6, acknowledged that Mr. Brooks both argued voluntary cessation and capable of repetition yet evading review, and the district court ruled on it.
Orally argued it or in his briefing?
I believe it was orally argued, and then the district court did rule on that.
I raised that point because I think we have the interesting problem here of things happening while the briefing has not been updated. And that point, I don't know if it was ever briefed. I know it was argued. Thank you.
Yes, Your Honor.
Did Mr. Brooks ask for kind of a system-wide injunctive relief or that would apply to other disabled prisoners, or was the remedy only directed to him personally?
Your Honor, Mr. Brooks, while litigating pro se, did request system-wide relief. He requested relief that would follow him to any institution, as well as targeting the training that the CDOC did. However, system-wide relief is not required for his case to not be moot, because the voluntary cessation exception and the capable of repetition yet evading review exceptions to the mootness doctrine apply. First, to defendants' choice to cease their offending conduct. The defendants bear the burden of showing that their conduct can't reasonably be expected to recur and that the effects of their behavior have been completely and irrevocably eradicated. But defendants have not met this burden. Mr. Brooks remains subject to policies allowing CDOC to transfer or revoke his accommodations at any time. And the defendants have not put any evidence into the record that their behavior or that the transfer and accommodation of Mr. Brooks is permanent in any ways.
Excuse me, Chief Judge Timkovich's question then, you are challenging policy system-wide, or are you not?
Yes, Your Honor. We're challenging that the defendant CDOC does not properly train its employees in how to reasonably accommodate disabled inmates, and Mr. Brooks did challenge those policies and ask for relief that follows him at any institution. And the record,
but he has the relief that he wants. He's succeeded in obtaining that at the Sterling facility, right?
Well, Your Honor, he had, and you know, this isn't on the record because we just recently found out, but CDOC has already revoked Mr. Brooks's movement pass. It was revoked as part of COVID lockdowns, and as those restrictions have eased, the CDOC has refused to reinstate it. I'm sorry, did I talk over someone trying to talk?
No,
now that's not in the record, correct?
That's correct, but this only goes to show, and we don't need to rely on that extra record fact. This only goes to show that if this case were affirmed as moot, the CDOC could pull Mr. Brooks's accommodation the very next day.
All right. Since you've already got, we're not supposed to go out the record, but since we're already out there, has the passes for diabetics also been suspended during the COVID lockdowns?
I believe, yes, it was during COVID lockdowns. However, those lockdowns have been since eased and passes have begun to be issued again. And Mr. Brooks has again requested.
Okay, so diabetics have now been reissued their passes.
That's my understanding, yes.
Outside the record. But Mr. Brooks' pass has not been reissued.
That's correct.
All right, we have to be careful about this because we have no record on this.
Absolutely. And on the evidence in the record today, still, Mr. Brooks's claim is not moot. And defendant's position is also wrong as a matter of policy. If the defendants were able to moot out Mr. Brooks's claim with their voluntary conduct, it incentivizes CDOC to just transfer every inmate who ever brings a claim for injunctive relief as a litigation strategy. Now I see I'm out of time. Out of respect for my co-counsel's time, I'm going to yield the rest of my time to her.
All right, we'll turn to Ms. Robbins.
May it please the court, my name is Asia Robbins and I will be addressing the merits of the Title II issue. Your Honor, summary judgment was inappropriately granted on the question of whether diapers are a reasonable accommodation for Mr. Brooks, because a reasonable jury could very well decide that diapers do not provide meaningful access to Mr. Brooks's meals, especially in light of an alternative, easy to administer and effective accommodation that Mr. Brooks once had, but CDOC revoked and refused to reissue, and that is the movement pass in this case.
Is reasonableness, in your view, always a question of fact, or is it rather a question of law?
Reasonableness must be a question of fact in this instance, and a question of fact more so for the jury to decide. And the record is replete with evidence that shows that diapers, when presented to Mr. Brooks as the proffered accommodation, were unreasonable. In fact, CDOC's diet miss record.
The question is reasonableness a question of fact or a question of law? So I think what Judge Timkovich is searching for is do you have a case on point? Hopefully a 10th Circuit case.
Yes, Your Honor. I do have a case, Wright versus New York State Department of Corrections. And the proposition of that case is that a defendant is only entitled to summary judgment if the undisputed record reveals that the plaintiff was accorded a plainly reasonable accommodation, because there's a reference to the record in that case.
What court is Wright from?
That's from the Second Circuit, Your Honor. However, reasonableness is a question of fact for the jury to decide, especially in this case where Title II, by this court's own precedent in Robertson versus Los Animas County Sheriff's Department, requires not just physical access under the reasonableness determination of the ADA, but meaningful access. And that itself is also a question of fact.
Ms. Robbins, I have a question. There is a document in the summary judgment proceedings called Diet Miss Chart.
Yes, Your Honor.
Familiar with that?
Yes, Your Honor.
And the state says that during the period when he was allowed this pass, and I think it's a 3 or 4 month period, March to June 2012, he missed 149 meals. Now, have you done a comparison of other comparable 3 to 4 month period?
Yes, Your Honor. In fact, the record
How
shows
do the numbers compare, and what are those periods?
Yes, Your Honor. The record shows that in the 8-month period directly after Mr. Brooks's movement pass was in fact revoked, he missed nearly 2/3 of his meals. And during one particularly dire 3-month period, in direct contrast to.
But see, I need to work with comparables.
Yes, Your Honor. So
I want to work with 3 or 4 month periods, or I want to work with percentages, which means you're going to have to tell me what percentage of missed meals are 149 that the state claims during this 3 to 4 month period when he had the pass. So I need to know percentages for the other periods, or I need to know absolute numbers for comparable periods of 3 to 4 months.
Yes, Your Honor. During one comparable 3-month period when Mr. Brooks was offered only diapers as an accommodation, the record reveals that Mr. Brooks would have been able to access nearly 100% more of his meals if he had been offered the movement pass at that same time. So he was only able to access 1/5 of his meals, as opposed to 146 out of, a half of his meals, if you will, during the period when he had the movement pass. And so this reveals that
you're going to have to tell me, during the period that the state says there were 149 missed meals when he had this pass, what percentage of meals are those?
He was able to access a little bit. He was able to access nearly, I think it was 55 to 60% of his meals when he had the pass, as opposed to only being able to access 36% of his meals to 20% of his meals when he did not have the pass, Your Honor. Depending on the time range.
Can you translate those percentages to numbers?
I can't off the top of my head, Your Honor.
I don't want you to spend time. Go on, proceed where you were going.
Yes, Your Honor. I think it might be useful to spend the remainder of my time clearing up a point of confusion between us and opposing counsel. Opposing counsel admits on page 7 of their answer brief and page 53 that if Mr. Brooks is just allowed the time to use the restroom before he goes in to get one of his meals, then he has a 30-minute window where he will not suffer a flare-up. And so the reason that Mr. Brooks requests the movement pass in this instance is because during the 2-hour chow pull period, when his unit could be called to go to the dining hall, all inmates are locked down in their cells, and Mr. Brooks does not have access to a restroom. So if Mr. Brooks is allowed the movement pass, if Mr. Brooks is allowed to know that he will go to the dining hall for chow pull at 6 a.m., noon, and 5 p.m., he will be able to access the restroom, and as defendants admit in their briefing, not suffer a flare-up during the time when he needs to access.
Doesn't he have a toilet in his cell?
No, Your Honor, he does not. He is in a dry cell at Sterling Correctional Facility.
What was he in at Fremont?
Believe he was also in a dry cell. There's no record citation for this. Unfortunately, we learned this from an interview with him, and we were reticent to cite it in our briefing. However, I do feel like it is a pertinent point of law for this court to understand.
The fact is important to this case because what you've now said is the pass is tied to when he can use the bathroom and also when he can access meals.
Yes, Your Honor.
So you're telling us that at Sterling he's in a dry cell. Is that in the record, or is that just what you have discovered since outside the record?
That's what we have discovered since outside the record. However, the lockdown procedures is in the record, and the full detail is described on page 18 of our reply brief. However, I see I'm running out of time.
Just a minute. Does the record indicate whether he was in a dry cell or not when he was at Fremont? The record, not what you know.
No, Your Honor, it does not.
Then it appears that when Mr. Brooks was operating pro se, which he was during the entire period when this record was being composed, is that nobody, Mr. Brooks or the state, put in any information about whether he was in a wet cell at Fremont or whether he was in a wet cell at Sterling, or which of the various prisons throughout the state have available wet cells. Is that a fair statement that the record has none of that information?
Not that we are aware of, Your Honor. I do see that I'm running out of time.
I'll give you some rebuttal, but because of that understanding, did he wear an adult undergarment then full time?
No, Your Honor, but Mr. Brooks' refusal to wear the undergarment does not weigh on the reasonableness of the undergarment in the first place. Because the proffered accommodation was in fact unreasonable, Mr. Brooks the CDOC foisted an unreasonable choice upon Mr. Brooks. They said either go to the dining hall, wear the diapers, attempt to withhold these flare-ups, withhold the pain, and then when you can't resist any longer and are forced to defecate upon yourself, then you must incur risk of assault from other inmates and attempt to eat in that environment, or the alternative choice is to not eat at all. And so that unreasonable choice is what CDOC has provided Mr. Brooks with their proffered accommodation, and a reasonable jury would most likely agree that that is not a reasonable choice at all, Your Honors.
All right, well, let's hear from Colorado now. See, Ms. Lawrence, are you?
Yes, good morning, Your Honor.
There you are.
Thank you. And Your Honor, if I could briefly address some of the points that were made in opposing counsel's argument first, and I'd like to start with voluntary cessation. In fact, Mr. Brooks in the lower court never argued or briefed voluntary cessation. And this is the exact reason why arguments as to exceptions to mootness shouldn't be considered for the first time on appeal. Had he raised that argument below, we could have presented evidence on that issue in a very straightforward way.
Did he have the opportunity to brief that before the court heard the case on the merits?
Your Honor, presumably, because what happened is between the time of the initial summary judgment briefing and the supplemental briefing, we had a motion hearing. And at that motions hearing was the first I found out, and the court found out, that he had, in fact, been given the pass he wanted. So in that hearing is when we addressed that issue, and then the court allowed supplemental briefing upon request on the issue of his Eighth Amendment claim.
Well, he clearly argued in the hearing before the district court that they could take this away again, the pass, didn't they?
That's correct, Your Honor. The only remark he made in passing reference any mootness exception was implying that it was capable of repetition, but I'd like to address that as well. So if you look at the capable of repetition doctrine,
when the fact that he says that he can be moved, I mean, I don't understand how, if he raises generally the fact that this can be revoked again, how that doesn't, generally reflect upon, at least for a pro se party, that they voluntarily ceased this, but they could resume it. I mean, there's lots of overlap between those concepts, aren't there?
Your Honor, I think the issue is I agree he arguably raised one prong of the capable of repetition analysis, but he never addressed voluntary cessation, which requires proof that the CDOC acted basically in a way to deprive the court of jurisdiction. And that was never argued. No evidence was presented on it. With respect to capable of repetition, I understand he argues that he could be transferred at any time. But under applicable law, and I'm referring to McAlpine versus Thompson, a hypothetical possibility isn't enough. And I can't emphasize enough that Mr. Brooks's history in the CDOC does not support this hypothetical possibility.
How do you establish under that concept capable of repetition without a hypothetical? If they've ceased the conduct, if it's resumed, it's hypothetical. How can you address that? otherwise?
Because, Your Honor, there's absolutely no evidence of that in the record. And what we're doing is reviewing the court's order on a motion for summary judgment. And what we need to look at is the undisputed facts presented to the court at that level. And there's no evidence that anything has been revoked. And again,
wait a minute, what you are arguing then is that the way you establish capable of repetition yet avoiding review is to demonstrate that they have actually resumed their conduct. That's what you're arguing. And that can't be true. It defies the definition of the concept.
The concept requires that he establish a reasonable possibility that the conduct will resume again in the future, and he has not done that, and there's no evidence in the record that supports that.
Well, don't we have here the bare fact that he has been transferred? He went from Fremont to Sterling.
Your Honor, he has been, that's correct. In 7 years' time, he has been transferred once. And again, that's additional evidence to show that what he's implying could occur is an extremely remote hypothetical possibility. He's been at Sterling for over, I'm sorry, Your Honor. He's been at Sterling since April of 2018, and he was at Fremont for 6 years before that.
How many years does he have to serve? Does he have like 60 years or something to serve?
I believe he has 4 consecutive sentences for his securities fraud convictions, Your Honor, and I don't recall the exact number.
Well, it's a lot of years, isn't it?
Yes.
And so if you just assume that he's transferred the maximum every 7 years, that's a lot of different places for him to visit, right?
Theoretically, but again, theoretically isn't the standard for capable of repetition.
You're going to have to help me on this. You're going to have to help me on this. You keep saying you cannot do it, establish it theoretically. You cannot establish it by hypotheticals. But if you establish it by actuality, then there's actual resumption. I don't see how you resolve that problem here.
Your Honor, because he hasn't shown that there is a resumption of the activity. And there's also 2 prongs to the capable of repetition argument.
The concept I'm talking about, and that is capable of repetition in avoiding review means the conduct that is sought to be enjoined has not yet been resumed, but there is a risk that it could.
Yes, there is a risk that it could, but that doesn't meet the McAlpine test. If I could move on to the system-wide argument, which was also addressed by counsel during their argument. They've indicated that Mr. Brooks has been challenging a system-wide policy. And what I'd like to focus on is the policy at issue. The parties are in agreement that Mr. Brooks has been requesting a movement pass, and that movement passes are governed by Administrative Regulation 300-55. And that's included in the as an attachment to our motion for summary judgment. I think it's important to emphasize that the system-wide test regarding mootness requires that a plaintiff challenge a policy that generally applies in a uniform fashion throughout the system. And what I'd like to point to court to is to that administrative regulation regarding passes. It relates to offender movement in general, which includes passes, and specifically states that it is to be applied and implemented in a facility-specific way. And that's based on the fact that under statute, CDOC facilities have a number of different security levels and classifications. Basically, there's no one-size-fits-all.
Okay. Are you're saying the Department of Corrections said 2 different things as to why he shouldn't get the pass after it was revoked in Fremont. Number 1, security. And then Ms. Russell then said, it ain't my job. That belongs to the medical coordinator. Those are 2 different reasons given. What was the security difference as to this prisoner or system-wide at Fremont during the period when he had the pass and during the substantial amount of time when he did not have the pass? What was the security difference?
Sure, I'm happy to discuss that, and I'm glad you brought it up, Your Honor. The security difference is addressed First of all, it's statutorily based. Colorado revised statute.
Actually, as to this defendant in this, why was he a security risk when diabetics were not? No diabetics were, as far as we can tell.
Your Honor, two things, if I may. First of all, we're dealing with two different levels of facilities: Fremont Correctional Facility and Sterling Correctional Facility.
No, I'm talking about Fremont. While he was at Fremont, what were his security risks when he had the pass, and what was his security risks when he didn't have the pass?
Okay, so the declaration of Julie Russell addresses security concerns, but also they relate to the fact that the Medline pass that he had briefly in 2012 is specifically created for individuals who have medical needs and need to take medication with meals. It's not a infinite list of inmates that can go through that line. It creates security issues.
Why did
any movement that's uncontrolled?
Wait a minute. Why did he qualify from March to June 2012 and did not qualify after that?
Because he was taking medication that required him to go eat with his medication.
So the record indicates that
Yes.
once he quit that medication,
Yes.
they took the pass away.
It
When
did not,
he-
it expired, yes.
At Sterling, is he taking medication that he has to have the pass?
There's no evidence in the record that I can't answer that based on the evidence in the record.
So that it indicates that you don't need to be taking medication to get the pass at Sterling, correct?
It doesn't, Your Honor. There's no evidence in the record one way or the other what his medical situation or medications are right now.
Why is he given the pass at Sterling? Is that an individual decision by an officer?
Based on Mr. Brooks's statement at the motions hearing, Your Honor, it appears to be so. Yes.
Does Ms. Russell have jurisdiction over Sterling?
The record does not establish that, Your Honor. No, she had jurisdiction over a certain regional facilities, including Fremont, but was not.
Well, help
There's
me.
no
With,
information as to
well,
Sterling.
help me with the geography. Is Sterling close to the Fremont?
No,
facility?
no, they're several hours apart, Your Honor. So one thing I wanted to address as well is counsel brought up bathroom access, or I'm sorry, the Medline pass that Mr. Brooks had briefly in 2012, and disputes the fact that when he had that pass, his meal attendance was not significantly improved. I would ask the court to look at that data. It's attached as an exhibit to our reply in support of summary judgment, and shows the sheer number of meals that Mr. Brooks was missing did not substantially improve even when he had that pass. For the 3-month period.
Wait a minute. We heard an argument that is disputed. Do you dispute the percentages that were given to me by Ms. Robbins?
Your Honor, I don't have percentages, so I can't dispute or not that information. What I have is the raw data, which was provided to the court in the diet miss log.
Are you telling me that there is no 3-month period after June of 2012 where he had anything, I guess, more than 149? Would you say he had 149 misses?
Yes.
Or meals?
149 misses in a 3-month period. And I'm glad you asked this question, Your Honor, because if you look at that chart, you can see that beginning in 2013, his meal attendance improved significantly. So, and that he didn't have a Medline pass during that time. If, for example, you turn to 2013, and in particular, starting from May onward, his meal attendance skyrockets. It goes up. So this
What
argument,
about 2014?
it's great in 2014 compared to 2012.
Okay.
And I think, Your Honor, part of this is because he had been placed on Humira.
Wait a minute. So you're telling me if I go through this diet miss chart, I do it on my own rather than you doing it for us, that I can go to 3-month periods throughout that whole time, and 149 misses, he seldom goes significantly over that.
Correct. So he's missing an average of 50 meals a month in 2012, the 3 months he has the pass. Then after that, he goes to an average of he stays in the 50s for several more months. There's a brief uptick between October and December of 2012, and then it goes back down again. When we get to March of 2013, which is less than a year later, he's only missing 8 meals. He's only missing 9 meals in April. So the data itself is extremely telling as to Mr. Brooks's meal access because it wasn't significantly improved when he had the pass.
My question is, does your concept apply for every 3-month period that's on this chart? And that is that there was no significant increase in missed meals.
Again, Your Honor, the only brief uptick was a 3-month period between October and December of 2012.
Just answer my question. My question is, if I look at any 3-month period, there's going to be no significant uptick in missed meals.
Correct.
Why don't we have a fact question here for the jury on reasonableness? I mean, there's obviously your opposing counsel disagrees with that interpretation. We're here on summary judgment. Why shouldn't a jury have evaluated this record?
Well, crucial to the court's decision below, Your Honor, was the fact that Mr. Brooks conceded that adult undergarments are reasonable for individuals who have uncontrolled incontinence, and then also admitted that he in fact suffers from uncontrolled incontinence. So he had conceded this fact he had tried to argue, which was that they were categorically unreasonable.
Are you taking his statement out of context?
No,
Was he
Your Honor.
talking about his own situation, or what was the question posed to him? You know, if you have this type of condition, which you have, is it helpful to have these diapers? And he says, yes, these older people, it seems to help them. I don't see that as a concession of his position in this case.
Your Honor, and I believe the statement you're referring to, he said later. What I'm referring to are the 3 separate statements he made at the trial court level, acknowledging that he had uncontrolled incontinence. And I'm referring to 3 entirely separate statements of him explaining in detail the unpredictability of his condition at volume 7, page 238 to 239, page 246, and page 262. And those are all in his deposition from 2018 before the summary judgment briefing in this case, Your Honor. And so the undisputed facts before the court at that time showed that they would be reasonable for someone with Mr. Brooks's condition that he himself admitted to having.
Okay, your time expired. Are there any other questions from the panel? Thank you, Ms. Lorenz, and Ms. Smith, if you'd put on 3 minutes.
Thank you.
Model, please.
Judge Timkovich, 3 minutes, did you say?
Yes, sir. Yes. Okay, I don't know how you want to split your rebuttal, but you may proceed.
Just a minute, I have a question. Ms. Robbins, what do you say about Ms. Lawrence's assertion that if you check, as she did, every 3-month period following June 2012, when he didn't have the pass, it will show no significant additional missed meals over the 149 during the period when he had the pass?
That is a false assertion, Your Honor. And in fact, from I believe it was October 2012 to January 2013, Mr. Brooks missed almost 80% of his meals as a result of being offered only diapers.
How many meals is that?
I'm really sorry, I don't have the raw data for that 3-month period. I do have the raw data for the 8-month period directly preceding after the meal pass was revoked.
Does that 8-month period average out to more than 149 per 3-month period?
Yes, it averages out to a meal miss rate of 64%, so almost 2/3 meal miss rate, Your Honor. And as opposing counsel recognized, Mr. Brooks was shortly thereafter put on Humira, which did manage some of the effects of his disability, especially the pain. However, that does not undermine the fact that the movement pass, in his most dire time of disability, granted him additional access to his meals.
All right. Does the record indicate that at Sterling, that he is on medication, and that's why the pass was resumed.
Your Honor, I believe
They're saying the justification for the pass is only if he's taking meds. Okay. At Sterling, has he resumed taking the meds, and that's why they granted the pass? And does the record show that?
No, Your Honor. I believe it was a clinical services administrator, Ryder May. She granted the pass just based on Mr. Brooks's request, which goes towards the voluntary cessation argument that my co-counsel was making. Mr. Brooks, as soon as this court ruled in his favor and remanded to the district court for resumed trial, the CDOC basically transferred Mr. Brooks and then granted him the accommodation that he wanted, which is enough to create a genuine issue of material fact regarding the behavior here. I would like to also...
Why is the final point that Ms. Lorenz made, and that is that your client agreed that that the adult undergarments would be a reasonable approach for incontinent prisoners. Why doesn't that concession effectively establish a reasonable accommodation here?
Your Honor, because Mr. Brooks's disability is not best characterized as incontinence. As opposing counsel concedes in page 7 and page 53 of their briefing, Mr. Brooks is able to, if he has time to use the restroom before meal times, have a 30-minute window where he will reasonably not have a flare-up. If Mr. Brooks is just allowed to use the bathroom before going to meal times, he will not suffer from incontinence. That's why the diapers are an unreasonable accommodation. And I would like to point out that we also, during Ms. Lorenz's argument, found the record site for the dry cell at Sterling. It's volume 7, page 283. It's Exhibit L to CDOC's own motion for summary judgment. So that is evidence within the record. I'm sorry that we overlooked it before. However, I do feel like it's pertinent to the considerations here.
But when you look for that, did you look, have we confirmed that it was a dry cell at Fremont? I forgot.
It's a dry cell at Sterling, Your Honor, but because the injunctive relief sought
Oh,
here is
not Fremont. I understand it, but at Fremont, have we confirmed that he was in a dry cell?
No, Your Honor, just at Sterling.
Okay, fine.
All right, your time's expired and the case shall be submitted. I just want, before you drop off, I want to compliment Mr. Cushing and the University of Colorado Law School student program. These arguments aren't easy to do for seasoned lawyers, and we have two 3Ls with us this afternoon or this morning. And anyway, I compliment you on your arguments, and obviously very well prepared. And I compliment the law school in taking on cases like this that otherwise would not have effective representation. So good luck with the rest of your school year. We appreciate the program, and you are now excused, and the case, as I said, is submitted. Thank you.
Thank you, Judge.
Thank you.
Thank you, Judge.
Judge Timkovich, I have to talk to Laura. I keep getting a notice up on my screen. I have to use something called Pulse Secure because I'm working remotely from my home. And it tells me it's going to time out in 11 minutes. Are you there, Laura?
Yes, I am.
Can you tell me, am I going to have a problem? Am I just going to get cut off when the Pulse Secure?
I have that same problem at home. And unfortunately, I've never used a camera at home.
when you're ready.
Thank you. May it please the court. My name is Kristen Wagner. I and Jonathan Scruggs and Kate Anderson represent 303 Creative and Mrs. Lori Smith. I hope to reserve 4 minutes for rebuttal. Subject to the court's questions, I will focus on Ms. Smith's standing and free speech arguments, but would first like to comment on 3 stipulated facts, because 2 simplify the standing analysis and 1 simplifies the merits. The district court found standing on the communication clause claim, and the reasons apply equally to the accommodation clause. First, the parties have stipulated that Ms. Smith has immediate plans to create custom wedding websites, with an example found in the record at Appellant's Appendix 2-333. Second, the parties have stipulated that Ms. Smith has not engaged in that speech because Colorado claims that it will violate its non-discrimination law, CADA. As to the merits, the Supreme Court in Hurley held that a speaker who serves everyone has the First Amendment right to decline to express messages that violate her conviction. Here, Colorado stipulated that Ms. Smith serves everyone, that she declines to create speech based on the requested message, and that every website she will create expresses a celebratory message about that marriage.
So just so I'm clear, the state has stipulated that Ms. Smith does serve gay customers for the other aspects of her web design business, other websites that she creates. Is that correct?
Yes, the stipulated facts are in the record, and at section 2-322 of Appellant's Appendix, they've stipulated precisely to that fact, as well as on 323.
So her product is a website. And do we know what the website looks like?
We do. In Appellant's Appendix 2-333, there's a specific example of the website that she wishes to produce. In addition to that specific example, the stipulations themselves also explain the messages that she would like to create, including expressing celebratory messages about marriage between a man and a woman, and to be able to use those opportunities to celebrate and promote her religious views on marriage. These types of statements...
Why wouldn't she be able to give the same message if she's doing a website for people who are gay?
Because the message is different. In the stipulated facts and in the sample that is found at 233, you can see that it tells a unique story of the couple's love story, not just simply an announcement of a wedding, but instead is sharing their love story with words and graphics as well. It's pure speech. And the Supreme Court has said that in pure speech instances that the compelled speech doctrine applies as to strict scrutiny. That would be the case here as well.
Wait a minute. It is the customer who tells the drafter of the website what they want in the website. Isn't that the way it works?
Not necessarily. In fact, the stipulated facts say that while sometimes the customer may come and give some general information, that the actual website is the creation of 303 Creative and Mrs. Smith. She creates custom artwork, she uses pictures, she uses text to create the imagery and the messaging about telling the story of that couple.
What is there in, I guess, a prototype? You're saying she has a prototype website. What is there in there that she could not make available to people who are gay?
In the record at 2-322 as well as through 325, it's very clear that this is not a prototype. This is not a plug-and-play type of website where you just insert names, but it's unique, original, custom artwork and custom speech that's created to tell that particular couple's story. And that's a message that Ms. Smith can't create because of her convictions about marriage between a man and a woman. In her business, the stipulations are also that she treats same-sex marriage and the messages that would be involved in the website the same as any other customer who would ask her to create a message that violates her convictions. She cannot do so, and the compelled speech doctrine protects that.
Ms. Wagner, I'm trying to kind of grapple with this distinction between status of a customer and the message that's being expressed through the creation of the website. And now, but this hypothetically, let's say a wedding planner, heterosexual wedding planner came to her and said, I want to have 5 mock-up sites that I can show to potential customers. And Ms. Smith was asked to create 4 that celebrated a opposite sex marriage and 1 that created a same-sex marriage. Would she produce 5 different mock-up websites for that customer?
No, she would not, because it's based on the message that's being requested. Each wedding website is custom. I think Hurley, that the Supreme Court's case in Hurley, provides an appropriate framework, and this court's decision in Cressman follows that framework. Hurley says that when you have speech that in any way may touch on or relate to a protected class, the first thing that you look at is the speaker expressing something? Is it speech? And the second is that speech objected to based on the message? The way that the Hurley court determined that was to look at what was actually being produced, what was it saying, and does the speaker otherwise serve people from all different walks of life, including that protected classification?
In Hurley, were we dealing with a commercial advertising as we're dealing with here?
What matters here is that we were dealing with a public accommodation in both cases. And that was a parade association. That was a public accommodation under Massachusetts law.
But not a commercial advertisement situation.
We're not dealing with, Your Honor, we're not dealing with a commercial advertising situation in terms of commercial speech here. But if you're asking whether it was a for-profit entity.
Why aren't we? Why aren't we?
Because commercial speech and the doctrine.
She's putting this out on her website saying, these are the people, these are the types of people that I will serve and provide services to. Is that not a commercial advertisement?
That's not the statement under the communications clause that she proposes. It's not at all. It expresses her beliefs on marriage. And that's found at 2362.
And that she said, but she says she will not provide these websites to same-sex couples.
She says in her statement under the communication clause that she believes marriage is between a man and a woman and needs to express messages consistent with that. In addition, though, under the accommodation clause, we're talking about the creation of those websites. And I believe your question was, in Hurley, would it apply because Hurley involved potentially a nonprofit or an entity that wasn't a commercial entity? The answer to that is Hurley itself in the decision says that this compelled speech doctrine actually applies to business corporations. And the court has applied it to business corporations again and again. We can look at it applying to publishers, for example.
Well, yeah, why doesn't Pittsburgh Press fit here? And why isn't your client covered by Pittsburgh Press?
Because Pittsburgh Press had to do with using words to facilitate illegal conduct. And that's not at all.
Isn't that what is happening here? If it's illegal to discriminate against same-sex persons, isn't she doing that by her statement that she proposes?
She treats everyone equally, but declines to express messages if those messages violate her convictions. It may be the wedding planner, it may be a parent that requests it, it may be a sibling.
So you're saying if my religion tells me that I can discriminate against people, then I'm good, I can do that?
Oh, not at all. In fact, what we find in the court's decision in Hurley, as well as in cases like Holder and other cases, that generally applicable laws that regulate conduct require this court to apply strict scrutiny when they sweep in speech, when there's an impact on speech. And Hurley expressly says that as well as other cases. If we think about it in terms of other cases as well, we can look at the Miami Herald case, as well as different cases like Riley involving fundraisers.
Well, if we look at strict scrutiny, what happens there? If we go down that path with you.
If we look at strict scrutiny, Colorado has failed its burden in that. We know that from other cases, for example, Hurley, which is the specific balance in this particular context, Hurley said that you can't compel speech, that there isn't a sufficient compelling interest that's narrowly tailored. Strict scrutiny is not satisfied in any attempt to compel speech, which was at issue in that particular case. We also know that the case law requires Colorado to provide particularized analysis. So some sort of broad interest in eradicating discrimination is insufficient for several reasons. The first here is that it's over-inclusive. And by being over-inclusive, the state has no interest when Ms. Smith is serving everyone, but simply declining to express particular messages.
Isn't the exception you're asking for here? Won't that just swallow up the rule? I mean, I'm not a big fan of slippery slope arguments, but where's the limiting principle?
Not at all. In fact, it's a very narrow application. The narrow application, it only applies to those who are in the business of creating speech, and only when they're asked to create speech that is objectionable. And in addition to that, Colorado's principle has absolutely no limiting principle. This rule doesn't just protect people like Ms. Smith, it protects all speakers who don't want to express messages that violate their convictions. And that's because the compelled speech doctrine is anchored in human dignity. A Mormon filmmaker that may not want to promote Scientology, but actually did a film promoting Mormonism. Those types of scenarios. In terms of the narrowing application as well, the objection has to be to the message and not to the person. And that's the precise analysis that Hurley used in that case. And Janus, I think, is particularly compelling here, and that Janus is the most recent compelled speech case by the Supreme Court. And it says that compelling people to speak messages is always demeaning, that it betrays their convictions, and that speech on sexual orientation and gender identity and controversial issues deserve the highest amount of protection under the First Amendment. Creating neutral speech under Hurley, the court has said, is a decidedly fatal objection. We do not compel speech. If there are no further questions, I'd like to reserve the remainder of my time.
I do have a question. Can you hear me? Can you hear me?
I can, yes. Yes.
In the statement, the proposed statement that she wants to post on her website, her religious convictions and her expression are basically contained in the first two paragraphs, right?
Yes.
And the third paragraph just says that she's not going to serve people who want to have gay marriages, correct?
It explains, yes, her beliefs on marriage and that she's unable to design custom websites, custom speech.
So we should, have her full expression of her personal and religious beliefs if she just drops the third paragraph out, correct?
If Your Honor is asking about the communication clause,
I am.
but
I'm asking about her statement. If she would have her full expression if she didn't have that third paragraph in where she said she's not going to provide these websites to gay people.
But the court has to decide the underlying question because she has the right to.
But that's not my question. Isn't her expression of her beliefs, religious and personal, fully contained in the first two paragraphs?
Respectfully, Your Honor, I think that's beside the point, and that she is.
Well, you know what? If it's beside the point, we'll figure that out. You answer my question.
Well, what I mean, Your Honor, is that you have to answer the question of whether she can engage in speech before you can decide any other question. Because if it's legal,
I understand your position on that. I have a very simple question. Aren't her religious and personal beliefs fully contained in the first two paragraphs of that statement? And the third paragraph is not necessary for that. Yes or no?
The third paragraph is necessary for her to be able to cite what her beliefs are on marriage, and it violates.
So her beliefs on marriage is she's not going to provide her product to gay people.
No, that's not at all what the statement says, Your Honor. If there are no further questions, I would hope that the court would consider granting additional rebuttal time. Thank you.
Let's hear from Colorado, Mr. Olson.
Good morning, Chief Justice Timkovich, and may it please the court. The company's challenge should fail here for two reasons. First, the company has no standing to sue about a business it does not conduct. It's not in the wedding website business today, and administrative proceedings that may never take place. It's not shown a credible fear of prosecution.
Well, can't we say this is a pre-judgment, pre-prosecution action? I mean, they're anticipating that there will be prosecution if she presents and puts on her website the statement she is proposing.
Correct. And under this court's standing, or under this court's standing jurisprudence, they have to show that there's a credible fear of prosecution. Is the language here? It's a maximum $500 fine, and they haven't done that because they point to only 4 examples in the record of similarly situated professionals being facing administrative proceedings, and in the record at 1-26, pages 26 through 29, 3 of those 4 were dismissed with no probable cause finding. So there is no credible threat of prosecution that is required as this court held.
What would it take? What would it take for you to say that there is a credible threat? An actual prosecution?
Well, I think it would take at minimum an actual customer. And she said, I'm not going to serve this customer because of my beliefs. And I think much of what we heard during my friend's argument illustrate why this case is not ripe for review. These are all hypothetical uncertainties about what would happen. But at a minimum, there would need to be a specific customer and or a specific complaint, neither of which exist on the record.
Then you're really forcing her to break the law to establish standing. And that's really not what the credible threat cases say. Will this legal regime, either the commission or the private enforcement that we have, raise an inference that there's a credible threat of prosecution, so that the prospective plaintiff doesn't have to commit a violation before she can establish standing.
Well, Chief Judge Timkovich, I don't think that's the case here, because she brings a claim both for the accommodations, or for the discrimination clause and the advertising clause. And the only thing we know for certain is the text that the company wants to put on the website that they say violates advertising clause. But that has to be looked at in context here, because as Judge Briscoe rightly identified, the question here is, does the advertising clause limit the ability to, is it a public accommodation law which prevents incidental speech that goes to the underlying illegal conduct? And we don't know on this record what that underlying conduct is, because we have no customer, we have no examples, which is why under the ripeness doctrine,
what about the prototype that Ms. Wagner says it's in the record?
Well, I think the prototype actually shows why there's no standing, because we hear over and over again from my friend that it's a custom curated process, that it tells the individual's life story, and without a specific individual or customer, we have no basis to know whether the prototype will bear any resemblance to the final product. And under the rightness,
can't we assume is that if there's a website for gay people, it's going to show pictures of both of them, and they're both going to appear to be of the same sex?
Not necessarily, and I think the example of, and this shows why on the merits, the case is not one of expression of a message, but who they will serve. If Alex and Taylor have a wedding that come to the company and say, we'd like a wedding website that says celebrate our joy, we don't want any pictures of us, we want to talk about the joy of marriage, and the company, under the stipulated facts, would make that website if Alex and Taylor were opposite sex couples, and would turn that customer away if Alex and Taylor were same-sex customers. And so under same-sex marriage.
Can I follow up on that? Because as I asked Ms. Wagner, this status versus conduct issue is troubling to me. And it looks like she currently serves, without any objection, customers who are gay. And that's been stipulated in the record. But if a customer comes and wants to create a same-sex weddings site, she won't produce that. Is she turning away customers because of their sexual orientation, or is she turning them away because of the message that they want to communicate?
Well, the Alex and Taylor example demonstrates it's because of the sexual orientation, because a same-sex wedding is a perfect overlap with gay and lesbian customers, and she is turning them away in the Alex and Taylor example solely because they happen to be a same-sex couple seeking website services, and she would provide the exact same services to someone of an opposite sex. So you can't.
And if a gay wedding planner came to her and he was designing a website for a opposite sex marriage, she would serve that customer regardless of his sexual orientation, wouldn't she?
Well, the customer in this circumstance, Chief Judge Timkovich, is the couple getting married. They're the ultimate customer of the wedding, and in that circumstance,
the customers, the wedding planner's business.
Well, the identity of the couple, the sexual orientation of the couple, is the dispositive factor under the company's decision who to serve and whom not to serve. And whether or not there's a third-party customer in the rare exception, but in the mine run of cases, the people, the customers for wedding websites are the people getting married. And in those circumstances, it solely depends on whether or not it is a same-sex or opposite-sex couple as to whether the company will serve them under their claim. And I think this reliance on Hurley to say that because it's speech, therefore Hurley applies even in the commercial public accommodations context is simply misplaced. That would have disposed of Masterpiece Cake Shop at the Supreme Court, because there the baker claimed it was expressive speech. But the majority in Masterpiece cited Hurley for only one thing in Masterpiece, and that was for the bedrock principle that public accommodations laws that prevent discrimination do not run afoul of the First Amendment. And in Hurley, they recommended, the court recognized that it applied as to which organizations, not which people, but which organizations could participate in a private parade. And they said it was a, quote, peculiar application of state law in that circumstance. And in that limited circumstance, they said that the parade organizer could dictate who could participate in the parade. We submit that the case controlling the outcome here is Rumsfeld, which talked about these public accommodation, or which talked about laws like public accommodation. There it was a Solomon Amendment that say you cannot, it's a conduct case. And of course, in conduct cases, there are some incidental speech that is put at issue about the law school in that circumstance, what they could say or couldn't say about the process. But you look at who the customers are under settled law, and if a customer is turned away, as the company wants to do here, because of their membership in a protected class status.
Why would you say that her dismiss speech is incidental to her business? I mean, in Rumsfeld, it was access to Harvard Law School or whatever, and providing a room really didn't endorse a particular message. But how do we draw the line between what is and is not incidental speech that's restricted?
Well, to be clear, Chief Judge Timkovich, the line is, does the government regulation restrict speech or conduct? And if it restricts conduct, is there some incidental restrictions on speech that accompany that restriction on conduct?
Didn't Colorado, though, stipulate that there was expressive content here?
Yes, because the rule doesn't matter what the content is. What matters under Colorado law is who the customers are, and you cannot be turned away for who the customers are. And this expressive, non-expressive distinction, I think, offers a false promise of certainty. The Supreme Court in Masterpiece could not agree as to whether or not Mr. Phillips' cakes at issue there were expressive or not expressive. And having a line that depends on a subjective discussion of whether something is expressive or non-expressive is very unworkable and creates significant administrability problems.
Do we have compelled speech here?
No, we do not have compelled speech here. No one is forcing the company to say anything.
Well, isn't the state compelling the plaintiff here to not say something? That is to fashion her statements in a certain way? That is to exclude statement.
No, what we are saying is the company cannot discriminate who it serves based on a protected class status. along with that restriction on conduct, who they can serve, we have the advertising clause, which says, just like the Fair Housing Act, the Age Discrimination Employment Act, that say you cannot advertise your intention to do something illegal, just as you can't do something illegal. So here, the company can either, with its beliefs, can either do what it's done, which is not make wedding websites, but make websites for all other customers, or if it's going to make wedding websites, it has to make them for people who are both Christian and Jewish.
So haven't you just described compelled speech?
No, because
you just said what the plaintiff could do to come properly within CADA.
As a business, the plaintiff cannot choose its customers based on protected class status, whether it's selling speech or non-speech items.
What do you do with the professional speechwriter or the professional filmmaker that would refuse to write a speech that celebrates same-sex marriage, or produce a documentary that would celebrate same-sex marriage when they would do a film or a speech on the other side?
Well, the question isn't what the content of their speech is; it's whether they would turn a customer away because of protected class status. And I think these are
they would turn the customer away because they didn't want to write the speech.
Well,
I mean, is that conduct, or is that compelled speech?
It is conduct, because it's a basic. No one is going to make a speechwriter write a speech about something that the speechwriter doesn't write speeches about for other people. The question is there a protected class basis for why that person was turned away? And it's a simple.
It seems to me in my hypothetical that there is a protected class reason that those customers will be turned away. I won't write a speech endorsing same-sex marriage.
Well, a viewpoint, again, keep in mind that the delta between the customer and the viewpoint. Mm-hmm. And here the question is, will he write a speechwriter write a speech for same-sex marriage for a gay or lesbian customer, the same speech that they would write for a heterosexual customer? Not the viewpoint in terms of what the speech says is not part of the analysis. And I do want to close on.
Wait a minute, Mr. Olson. Mr. Olson.
Yeah.
We look at the proposed statement, and vis-a-vis the communication or the advertising clause, if the statement was limited to the first two paragraphs, would there be a problem with the communication clause?
Not on that statement by itself.
Right. So the only problem with the communication clause comes with the third paragraph. Is that correct?
Yes, because that is the only part that says same-sex couples are not welcome in my business.
Yeah. Thank you.
The company can speak their beliefs all they want about their views. It's just a conduct-based question. Who is being turned away because of a protected class status?
So if the plaintiff wished to express her own views of same-sex marriage on a website or a same-sex marriage, she could say what she says in paragraph 2. It would seem a little incongruent, but she could say that.
Yes, what matters is whether someone is turned away because of their protected class status. The company and the company's owner are free to express views about a whole host of things. The question is, does that mean, are they violating the advertising clause, which would say, I will not serve people based on their status?
Doesn't that get us, we haven't talked about I guess that you called it the unwelcome clause in the briefing, and wouldn't those type of statements, if they were communicated within the business, make a customer feel unwelcome or demeaned, and wouldn't that violate that part of CADA?
Your Honor, my time's expired. May I answer briefly?
No, please.
Yeah. Well, So the only thing before the court right now is a facial challenge to the unwelcome clause. There is no specific facts. And certainly in some instances, one could imagine things that come very close to the line that says, for instance, have a entrance for same-sex, or for gays and lesbians than we do for heterosexual couples in our business. That would not say I'm not serving them, but that would be a good example of being unwelcome. So on the facial challenge,
like in this case, if the plaintiff here put her statement on the website and basically said, I will provide websites for same-sex marriages because the government's making me do that, and otherwise, would that make customers feel unwelcome?
Well, on that fact, probably not, because I think most of us understand that we have an obligation to follow the rules, and that us providing goods and services to the company or to the public in compliance with the rules doesn't necessarily mean we endorse all the rules that we're following, but that we live in a society where public accommodation means that to have a free marketplace, we all have rules to follow, and selling a widget or something doesn't mean I agree with all the rules that go with that widget.
How about a restaurant that flies a Confederate flag? Would that violate the unwelcome clause?
Probably, it would depend on the context. If it was a Confederate flag and only a Confederate flag, and it was located in Alabama, that would be one thing. But
let's stick with Colorado, downtown Denver, Colorado.
I think
across from your office on Colfax.
Well, I think it would depend very much on the context. In some circumstances, yes. In some circumstances, no. If there was a historical collection of flags, or it was flown in a way that invoked ridicule, or
so if I open a restaurant, I'm going to have to hire a lawyer to tell me whether this is good context or bad context. Why isn't that overbroad or vague?
Well, because I think these extremes illustrate why in the mine run of cases there is no concern. Because all it says is if you open a business, you have to serve all based on protected class status, and you can't turn people away solely because of who they are. And sure, there are going to be hard cases on the margins with Confederate flags, et cetera, but that is not a problem that faces most businesses in Colorado as they strive to comply with this law. And if that is a problem, that is certainly one that awaits review based on that specific fact pattern, not on the broad facial challenge that the company brings here before they even have a single customer or have made a single statement or designed a single website. So for the reasons we've discussed, and if there are no further questions, we urge that the court affirm the denial of the company's efforts to block the anti-discrimination law below.
Great. Thank you, Mr. Olson. We have some rebuttal time for Ms. Wagner. You may proceed.
Thank you, Your Honor. Let's make it clear that in terms of what Colorado's arguing is that they're arguing that they can compel speech, not conduct or services. It doesn't matter what label they place on it. It is speech that they're compelling, and it violates the compelled speech doctrine. The Eighth Circuit has decided a case very similar, Telescope Media Group, to this case and made that determination as well, as has the Arizona Supreme Court. Masterpiece did not deal with speech, but actually Masterpiece itself said speech would be protected in some circumstances under these laws. Subsequent cases play that out, including the Janus case as well. And the stipulations, Your Honor, may I finish my sentence?
You have, yes, I'll give you another 2 minutes because we went over with the state of Colorado. So, Laura, will you give her 2 more minutes, please?
Thank you, Your Honor. In addition, Ms. Smith is not choosing her customers, she's choosing her content. And we can look at many different cases that play that out in terms of publishers, fundraisers, and other entities as well, newspapers and so on. In addition to that, I think we need to consider the implications of this rule. Colorado's essentially saying that they can define public accommodation in any way they want and sweep in any speaker they want.
Isn't there a compelling interest in this case in the accommodation clause? Isn't there a compelling interest?
No, there is not, because the distinction is being made based on the message, not the person. Ms. Smith is treating everyone equally. She's essentially making all of her decisions based on the message, and that's stipulated.
Well, can't, can't the message discriminate?
Well, certainly the court has said in the past that the proudest boast of our free exercise and free speech jurisprudence is that we actually protect speech even that we dislike. But in this case, the message isn't discriminatory. It's exclusively focused on the fact that in this case, Colorado stipulated every website expresses a custom message celebrating marriage. For the first time, Colorado has claimed that this case might not be right or that more facts need to be developed. But that
okay, but I want to talk about strict scrutiny, and I want to talk about compelling interest and whether this provision is narrowly tailored. And I'm still trying to understand your response to compelling interest. If it is speech, hasn't it been narrowly tailored here? And isn't there a compelling interest by Colorado in passing CADA as it has to address discrimination against same-sex couples?
Not at all. It's not only not narrowly tailored, but this court and neither the Supreme Court have found a compelling interest in compelling speech. That simply hasn't happened. First of all, Hurley tells us that in and of itself. All of the arguments Colorado's making...
Well, is speech being compelled here?
Yes, it is. And it's a content-based regulation in addition to a viewpoint-based regulation. So there are three reasons that the court would apply strict scrutiny. Speech is being compelled because Colorado's saying if she dares to speak on marriages and her beliefs about marriage between one man and a woman through these websites, then she must speak an opposing viewpoint and celebrate.
If you can compel speech, can you not in certain instances?
The only time you can compel speech is when it's incidental, and the speech is not incidental. May I finish my answer,
Sure.
Your Honor?
Yes, go ahead and finish your answer and then wrap up.
The speech is not incidental, and the Supreme Court, as well as this court and Cressman and other cases, have held that a generally applicable law that does have a direct impact on speech warrants strict scrutiny. The promises of Obergefell and Masterpiece apply, and Hurley apply just as equally to the religious believer like Mrs. Smith as to any other speaker. Otherwise, those promises are hollow. No one should be forced to be compelled to express a message that violates their convictions. Thank you, Your Honor.
Counsel, I appreciate the quality of the arguments in this matter, and the briefing was also excellent. Counsel, you will be excused and the case shall be submitted. The court's going to take a recess until 10:30, so 13 minutes, 10:30 Mountain Standard Time.
Of the United States Court of Appeals for the 10th Circuit.
Thank you. We'll recommence. Judge Murphy, you're on mute.
Yes.
Okay, let's call our third and final case this morning, 20-1031, Rivera versus Exeter Finance. Mr. Brown, you may proceed.
Thank you, Your Honor, and may it please the court. I would like to reserve 3 minutes for rebuttal, if the court should allow. I represent Mr. Rivera, who is the appellant here, was the plaintiff down below. Mr. Rivera's motion for class certification, his second motion for class certification, was denied. And in denying that motion, Chief Judge Brimmer committed 2 reversible errors. The first one was that he did not address any of the Rule 23 factors in rendering his decision. And as the Supreme Court has said numerous times, and this court has said several times, the rigorous analysis of Rule 23 factors is the sine qua non of the class certification analysis and must be done. The second error was his basis for denying class certification was that the class was not ascertainable. And in reaching that conclusion, he applied the wrong legal standard. That is, he applied the Third Circuit's ascertainability standard, which the Third Circuit has created a requirement of administrative feasibility.
What evidence do we have in the district court's ruling that it applied that standard?
In the order on the second motion for class certification, Chief Judge Brimmer wrote that the plaintiff had not shown that the class was ascertainable, and then he cited to the Donica case.
We have citations to that heightened requirement, but in its verbiage, the court did not identify that requirement or address it. Is that not true?
The court did not state that it was applying that standard. That is true. And in fact, the court did not say what standard it was applying. All that we can discern from that order is the citation to the Donica case and the page cite, as well as the quotation. All of that, if you look to the Donica case, is a reference to the ascertainability requirement as stated by the Third Circuit in the Curiae case, which is the administrative feasibility requirement. So that's the reason or the basis for the argument that he applied the wrong standard. There is no indication that he applied.
Didn't you argue? You argued below, though, that a class needed to be ascertainable as sort of a foundation principle, didn't you?
Your Honor, that is correct. And in fact, if you look at the motion for the second motion for class certification, there is a discussion in there about ascertainability. Now, plaintiffs are not saying, an appellant is not saying here that ascertainability is not a requirement. The question is, how is ascertainability established, and what is it in Rule 23 that makes ascertainability a requirement? Because remember, this has to be based on Rule 23 and the rigorous analysis. So what you see in that second motion for class certification is the plaintiff appellant there saying, we acknowledge, Your Honor, your ruling in our first motion for class certification, wherein you indicated to us that we needed to have an ascertainable class. So his order in response to the first motion for class certification indicated, in fact stated, that an ascertainable class was required. So plaintiff responded to that.
Figure out what the class is, how can you apply the Rule 23 factors?
That is absolutely reasonable, Your Honor. And in fact, in Rule 23, at 23C, I believe, the court is required to include a class definition. And I think that's what the ascertainability requirement is referring to.
And what is the class definition here?
Well, the class definition in this motion, the class was defined as those 482 persons. Now,
That's puts the cart before the horse, isn't it?
it is not, Your Honor.
How did those 400 plus people get into the class?
Well, there is a detailed discussion of it in the briefing, but essentially what happened was the plaintiff was able to identify a few 100,000 people who were called by Exeter Finance. And then the plaintiff subpoenaed records from AT&T and was able to put those two sets of records together and come up with a list of about 2,000 people. Now, there were some people that needed to be excluded. For example, people who were already customers of Exeter Finance could not be in the class because those people ostensibly gave Exeter Finance permission to contact them. So there was a process involved in which plaintiff's counsel did their level best to come up with the list of people who were appropriately in the class and, submitted that list to the court.
Then let me restate my question. What is the definition of the class here?
Well, the class, if you're looking for objective criteria to define the class.
I'm looking for a definition that I can put in an opinion.
Well, it was submitted as an exhibit, so the order could refer to the exhibit, and that has happened before. It could be defined in a number of different ways if you want to use objective criteria. For example, you could say individuals who received phone calls from Exeter Finance that were not previously customers of Exeter Finance as a result of their robocalling system.
I guess I'm looking for what you asked the district court to certify. What class definition did you propose to Judge Brummer?
In the first motion for class certification, plaintiffs used a traditional definition for class certification. And it was essentially those individuals who received the unwanted calls from this auto dialing by Exeter and who Exeter was trying to reach a prior subscriber to that number. Because you'll recall that the persons receiving these unwanted calls have numbers that had previously been Exeter Finance customer numbers. And so,
what's the number of people that would fit into that class? What was the estimated number?
That original number was something just north of 800.
And so what is it in a definition that would cut out 300 to 400 now?
Well, that's a good question, Your Honor. And what happened was, in the context of that first motion for class certification, defendant Appellee pointed out several individuals who would be included, but actually, in fact, could not be class members because, for example, the person who had the phone number before them was not a subscriber to AT&T's service. And it turned out that the plaintiff himself suffered from that factual defect in that the person who had the number before him was not a subscriber to AT&T. He was an AT&T customer who had a prepaid phone service number. So the effect of it all was the same, but because of the way the class was defined originally, there were some individuals who, for one reason or another, were going to fall out of the class. Defendant pointed that out at the motion, and the judge refused to grant that motion because it found that the plaintiff himself was not a member of that class for that very reason, that the person who had the number before him was a prepaid AT&T customer, not a subscriber.
So are you saying that the 300 to 400 that dropped out between the first motion and the second motion were all people who were situated, such as Ms. Romero, the previous person who gave consent on this?
No, I'm saying there were a number of factors that they used, the plaintiff's counsel used to eliminate individuals who ran the risk of being not appropriate class members. There were some other factors involved. For example, if it was a number to a business, the TCPA will not apply to businesses who receive auto dialer calls such as that. So they eliminated those numbers too. So there were a number of factors that plaintiff's counsel looked at to just ensure that the individuals they were identifying were in fact appropriate class members.
Does the list now include only AT&T customers?
Yes.
What about all? Surely there must be other customers of Verizon, Sprint, and others that are not on this list.
Absolutely, Your Honor. That's an assumption that we can make. Class discovery was permitted on this issue, and plaintiff served a subpoena on AT&T. I think the court's question is a good one, but remember that there will never be a complete list of class members. There's always going to be people who could be in the class who are not. For example, we don't know all the phone companies that people who had agreements with Exeter Finance used. There will always be.
But in your previous motion, you did consider users of other providers, didn't you?
No, it was based entirely on AT&T. And Your Honor, let me make this point if I may, because I see that I'm running out of time. The process that plaintiff's counsel went through here is not unusual. The timing of it is unusual, but this is the same process that happens in every class action when it's time, when there's a judgment or a settlement and it's time to distribute the money.
Mr. Brown, I've not seen a case where the class is defined just by a list. There are plenty of cases where once you define the class in the Queen's English textually, then you come up with a list of how many people to fit in. Isn't that what you're talking about?
Yes, traditionally that is how it happens.
And that's a completely different thing than we have here. But I want to ask you, isn't part of the problem here that you have an opt-out class rather than an opt-in class?
I don't believe that presents any problem whatsoever, Your Honor, and maybe I'm not understanding your question. But
well, would you be able to proceed with this if you had proceeded with an opt-in class?
Well, the motion was brought under 23B3, which is an opt-out class.
I understand. So my question is, could you proceed in this case with an opt-in class?
Are you saying would I or could I?
Could you?
I imagine that you could. The statute doesn't provide for an opt-in class, so I'm not sure how that would work.
Well, there are plenty of class actions that are opt-in classes, aren't there?
Sure, there are most class actions that are opt-in classes, though, are opt-in because the statute says that they need to opt in. So I think, at least in my practice, the sort of default has been an opt-out class unless you're required to do an opt-in class.
Can you respond quickly to the point that based on your methodology, your client is not a member of the class?
Sure, and that's an interesting point because obviously the methodology that was done in the first motion, that was true. The methodology applied in the second motion, that's not accurate because for the first point being that obviously he falls within the 482. But second of all, nobody doubts factually that Mr. Rivera received these calls and that Mr. Rivera should not have received these calls because he was never an Exeter customer. Nobody is stating that the rest of the 481 did not receive these calls or that they should have received these calls. So they all are similarly situated in all the important factors about this case, which are tied to the liability, of course. Having said all that, the argument that he is not appropriately considered a member of the class is really, by the way, one of typicality. What counsel is raising is the idea that under a traditional 23 analysis, the claims of Mr. Rivera are not typical of the rest of the class's claims, or that he is subject to a unique defense that the rest of the class is not subject to. So had the court done that traditional Rule 23 analysis, we could have litigated that issue and come to some resolution of it, but that didn't happen here. I see my time is up, Your Honor.
Thank you, counsel. Let's hear from Mr. Ramey.
May it please the court. Travis Ramey on behalf of Exeter Finance. Mr. Rivera has twice sought to certify a TCPA class action against Exeter. In his second motion to certify and in this appeal, depending on which definition is more useful at a given moment, Mr. Rivera has defined the class as solely a list of names, or by referring to the sort of ill-defined and at least partially subjective methods of filtering records. Under either of those class definitions, the district court acted within its discretion when it denied class certification. If the class is only a list of 482 names, then the plaintiff has really provided no class definition at all, other than sort of an ipse-dixit, because I say so class.
Well, that may be so, but the class is clearly ascertainable, isn't it? I mean, it's ascertainable. You look at the list, and you've ascertained what the class is.
Well, Judge Murphy,
doesn't that mean that the problem is something different than ascertainability?
Well, I would have, I guess, three responses to that, Judge Murphy. The first is that, of course, the court will affirm for an alternative basis if it decides to. The second is that the need to define class, an ascertainable class, is about more than the ability to count noses. It's also about allowing the trial court to evaluate the explicit requirements of Rule 23 and helping ensure that the class functions as a true Rule 23 class. My third response would be to say that
okay, so you're talking about commonality. You're talking about those factors, right?
Well, the need for a sufficiently definite and ascertainable class definition, Newberg on class actions calls this a precursor to the ability to do the express analysis of the Rule 23A and Rule 23B requirements. If you don't have a real class definition, it's not possible to do that express analysis.
Wait a minute, you have this list, and inquiry can be made of everybody on this list. You know, first of all, you know whether it's numerous. It appears that the questions of law by who was included are common to each of them, and that their claims are typical, and that there's commonality. Well, can't you do that just by checking the people on the list?
Well, Judge Murphy, I think that Rule 23C1 and 2 provide a yardstick for what a class definition has to include. And a list of names, even if it's possible to count noses, something that the district court acknowledged was true, it doesn't provide the type of definition that we use to define what is a class. It's just a list of individuals. I also think it's important to note that the district court's order is about more than just, can we figure out who the individuals in this class are? Yes, the judge mentioned that, but he also talked about how this list had been reached through a process that included subjective analysis. He was concerned about the accuracy of the list that had been generated by this analysis, whether it was reliable. He had other concerns that were just about a class definition more generally, about how the class was defined by the only common characteristic being presence on the list, which is not a personal characteristic, that the type of criterion used to generate, the type of criteria of being on a list is not the type of criteria we typically use.
But can't you tell from the criteria that was used to narrow this list down from the list in the first motion that criteria narrows us down to people who basically had not consented to receive calls, and that they received them. They had no relationship with Exeter. They received them on this phone number.
Well, Judge Murphy, I think there's sort of 5 problems with creating a class from the criterion. The first of which is that the plaintiff has insisted that the class is defined solely by a list of names. In fact, my friend in his opening argument made that same insistence. And the district court might have been able to cobble together some definition from that possibly, but that's not really the district court's job to do that. The second problem is looking at just these criteria. If that's what defines the class, then Mr. Rivera isn't part of the class. He fails at 4 separate parts of the criteria
if you just stop with the 2 criteria that Judge Murphy's listed, he would be part of the class, would he not? He received calls and he had no prior relationship with Exeter, period.
Your Honor, that's I assume correct, but if you look at the Walmart v. Dukes case, it touches on a bit of what Mr. Rivera's argument here, which is that he is in the class because he possesses the same interests and he suffered the same injury. But the Dukes case says there are 3 separate parts. That's 2 of the 3. But the third is that they must be part of the class. So that's a separate requirement that he be included within the definition. Now, if the idea again is that the district court maybe could have cobbled something together from the various pleadings, maybe, but that doesn't fix the rest of the problems, which is that these criterion that were used to create this list of 482 aren't clearly defined. There's no statement of what system dispositions were used to come up with the 4 bad number results. It doesn't say what commercial database was used to check these numbers. The district court really didn't have enough information to glean these parameters itself, and it really wasn't its job to do so. And that's separate and apart from the evidentiary problem that Mr. McDevitt, whose declaration is the basis, is not a qualified expert. And the second motion added new criteria to filter that list down and was not supported by a new declaration to do so. It's supported simply by records. That's the second problem. The third problem, these parameters are some of them are subjective, and we know that an ascertainable class must be ascertainable based on a reference to objective factors.
Give me an example.
Yeah,
give me an example of something that was eliminated by a subjective criteria.
Okay, an example of one of the subjective factors is a name or address similar. Is name or address information inadequate? Judge Murphy, you and I might come to very different conclusions about whether 2 names are similar. That's a judgment decision.
Oh, wait a minute. You're talking about, I don't think Rule 23 requires absolute, precise numbers. You don't have any mistakes. You don't have any mistakes of underrepresentation or overrepresentation. It can't be perfect. Clearly, what that criteria was intended to do was, for example, to get rid of people who were on a family plan. Isn't that correct?
Judge Murphy, I can surmise that maybe that was the intent, but the problem is part of this requirement to have ascertainability be about an objective in reference to criteria that are objective, is that when the plaintiff does that analysis of who meets these objective criterion, especially when it's simply based on records, the plaintiff and the district court should reach the same conclusion. The plaintiff's work should be recreatable. And here that simply isn't possible because we don't know what judgment Mr. McDevitt exercised when he decided whether something was or was not similar, when he decided whether something was or was not inadequate, when he decided whether something was or was not conceivable.
Well, you could reverse engineer it, couldn't you, and figure that out from figuring out what's the commonality of the 300 or 400 people who were excluded from the first one, from the first one?
Your Honor, given the lack of any real definition other than a class, I don't know that you can do that analysis. Particularly, it's also important, this was plaintiff's burden to put on evidence showing not that this was conceivably possible, but that it was effectively done by a preponderance of the evidence. And this just doesn't get there. There's another problem with this class, and Judge Murphy, you touched on it a bit in my friend's argument, and that is this class is fatally under-inclusive in its own definition.
Okay.
It doesn't include anyone that's not an AT&T customer. It's based only on a partial analysis of Exeter's records.
Go on. Okay. I can understand. You can put these subclasses if you wanted to. So right now we have the subclass of AT&T people. What is under-inclusive about it? That subclass.
Well, okay, it's based only on a partial analysis of Exeter's records. The initial database was only about half of Exeter's records. So we're already leaving out maybe half of AT&T's customers to begin with. We have 840 class members at the first motion for class certification that Mr. Rivera represented were necessarily part of the class. And now through the sort of additional filtration, we've gone from 840 to 481.
What is the problem with underrepresentation? You're not going to preclude those people if they don't opt out because they're not on the list. So what's the problem with underrepresentation?
Well, at a certain point, and I think we've reached that point, Judge Murphy, under-inclusiveness defeats the efficiency purposes of Rule 23. The point of allowing class discovery is so that the plaintiff can prove the initial class allegations. And yes, you can deviate, and yes, you can filter that class down and minimize it. But at this point, Exeter has engaged in a long, protracted discovery process involving thousands of accounts. And to get down to this point of 480 cases, Exeter will have spent all of this time, the court will have spent all this time to adjudicate this, and yet only a sliver of the hypothetical potential cases out there will have ever been resolved.
Mr. Ramey,
that's not the efficient process, Rule 23.
Mr. Ramey, aren't what you're saying is if there are some serious problems with this class, that it should not be certified, but there are reasons other than determinability. Isn't that what you're saying now? I'm not saying
no,
that's wrong, but
Judge Murphy, I think that the deficiencies of the class definition are on its face problematic. And it's not just a problem of superiority or typicality. It is a problem that was the problems that were identified by the district court in its order. You have a class that isn't really a class, that has been defined by non-traditional methods in a non-traditional way, that is based on subjective factors, that is a list of people whose only common characteristic is their presence on the list, that is perhaps more suitable for an opt-in if such a procedure existed class than it is the opt-out Rule 23 procedure. And all of that is apparent directly on the face of the definition without getting into the specific Rule 23 factors or elements, excuse me. And the other part, Judge Murphy, we all know that the individual Rule 23A requirements and the Rule 23B requirements, these aren't silos. They overlap. Just like the requirement for a class definition and ascertainability overlap. Given that this definition is apparently defective on its face, given the potentials for abuse of allowing a class to be defined simply by a list of names and the possibility of doing exactly what happened here, file a broad class and then winnow it down through fishing discovery, it's problematic. It also allows what ultimately this class definition is about. It's an attempt to bypass the problem that was present in the initial motion for class certification, which is that Mr. Rivera does not fit the class definition. This list is an attempt to tack Mr. Rivera onto what hypothetically could perhaps, if it were better defined, be a class, but would not include Mr. Rivera.
I could ask one question. Did the district court in this case apply heightened ascertainability?
Mr. Chief Judge, my time has expired. If I might have leave to answer.
Please answer the question.
Your Honor, there's no indication that the district court implied the heightened ascertainability, administrative feasibility requirement from the Third Circuit. It never once discussed administrative feasibility. It didn't even really say that the identity of the individuals would be difficult or impossible to identify. It did cite at various points to the Donica case, and I think there may have been citations to Curiae and Warnick, but it didn't discuss everything in those cases. And simply the fact that it cited to some cases that applied the administrative feasibility requirement does not mean that the district court applied that requirement, particularly when there's no other evidence that it did. We'd ask that the court affirm.
Thank you, counsel. Your time's expired. Absent any further question, counsel are excused and the case shall be submitted. Thank you, counsel. And if I could ask the panel to hang on for a few minutes for administrative purposes.
Your Honor,
your time was expired.
Did I reserve 3 minutes or not?
You used it up.
Okay, thank you. I was unclear. Thank you.
You did right.
I think we understand the arguments, though.
Sorry about that.
For the panel, I will call it 11:20 Mountain.
Well, I need how many minutes? Because I don't have a digital watch.
18 minutes.
18 minutes. All right. Gotcha. Thank you.